Hello and a very warm welcome. Thanks for tuning in to News 9 Live. We are going to discuss, albeit a very important reform that is now coming from the Supreme Court. The Supreme Court was expected to pronounce its verdict on a slew of petitions relating to the exercise of its vast and sweeping powers under Article 142 of the Constitution to dissolve broken down marriages between consenting couples without referring them to family courts for lengthy judicial proceedings to obtain divorce decrees. A five-judge constitution bench led by Justices S.K. Kaul is also expected to rule on whether the top court's sweeping powers under the provisions are hampered in any way when a marriage has irretrievably broken down in the opinion of the court, but one of the parties is still resisting and dissenting divorce. Section 13B of the Hindu Marriage Act 1955 that provides for a procedure for a divorce by consent. It requires the couple to approach the family court to initiate divorce proceedings, and then that 6-month to 18-month period that the court then gives to the couple to, check their decision once again. The court has now come out with that verdict. It says that it can annul irretrievably broken marriages, and that 6-month time period can be dispensed away with. But a lot of other questions that have now come to the fore as well. Joining me in the studio is Ashok Bhagria, legal editor. Ashok, first and foremost, for the benefit of the viewers out there, 142, the sweeping powers under 142, and how does this particular verdict now change the landscape when we've got two couples that don't want to be in a relationship in a holy matrimony anymore? How does that completely change the landscape? You've got the children, you've got their economic, and financial stability to look at. The 6 to 18-month period where couples would be asked to, go back and, ponder upon their decision making as well. How are you looking at the court's verdict today?
Well, firstly, let me tell you, it's a very comprehensive judgment which has been delivered by the Supreme Court today. So first things first, the court is saying that there is a mandate under law that if a couple comes to the court and says that they want divorce by mutual consent, then there is a mandatory cooling off period of 6 months. Now the court is saying that this mandatory period of 6 months cooling can be dispensed away with. And this can be done by the Supreme Court because Supreme Court of India enjoys extraordinary powers under Article 142 of the Constitution. The second thing the court has said that it has laid down some parameters and rules which will have to be followed by the courts while deciding as to what really constitutes an irretrievable breakdown of marriage. Now, couples generally approach the Supreme Court when there is no chance of reconciliation, and this period of 6 months cooling off period was introduced by the Parliament to ensure that no hasty decision is taken, because there have been a rising number of instances where a couple get married and want to get divorced the very next day. So to tide off such situations, the Parliament in its wisdom had introduced this 6 months cooling off period. But here what the court is saying is that if a couple comes to the court saying that the marriage has broken down completely and there is no chance of reconciliation, then the court will look into the facts and circumstances of the case and can dispense the 6 months cooling period and pronounce divorce immediately.
And what does this mean for 13B of the Hindu Marriage Act?
See, the 13B thing still remains. 13B provision will remain. The court has not tinkered with it in any way. The provision still remains. Now there are couples who come to the Supreme Court, who go to the courts under various heads seeking divorce. Now the court is saying that this provision of cooling off period will be there. It will depend on the presiding judge to determine whether this period can be waived off or not. Now what has really happened is that in the last decade or so, the Supreme Court has been flooded with a spate of litigation where couples, instead of going to the family court in the first instance, come straight away to the Supreme Court. They come to the Supreme Court, tell the Supreme Court that they have worked out an arrangement amongst themselves. They have decided that they are seeking divorce by mutual consent, and the Supreme Court should not insist on the fact that that 6 month cooling off period be there and pronounce divorce immediately. Now, in the past, the Supreme Court has done that. However, the Supreme Court wanted to test whether it actually had the powers, the extraordinary powers to dissolve marriages and bar out the jurisdiction of lower courts. So basically what really happens is that when you file for a divorce, you file for a divorce not straight away in the Supreme Court. There is a proper hierarchy of courts which has been laid down. The jurisdiction is of the family court. The family court will look into the facts and circumstances surrounding the marriage and look at the fact that whether a cooling off period is mandated or not, and then subsequently you can go to the High Court and finally come to the Supreme Court. However, what has really been happening is that people have straight away come to the Supreme Court, said that, look, the fact of the case is such that my marriage is broken down. Now, why does the law insist on this 6-month cooling off period? We don't want to stay. We've worked out an agreement between us, and despite that, why am I being forced to continue with my spouse with whom I don't want to be? So the Supreme Court said, okay, we'll allow that. However, what will have to be kept in mind is that in case that couple has children, the maintenance rights, the alimony rights, the rights of the children, everything will have to be taken into account by the Supreme Court as well as the other courts, and then pronounce divorce. If it is waiving off or dispensing the 6 months waiting period, the courts cannot shut their eyes to the fact that there will be rights which still need to be decided. There will be this right of a woman for maintenance.
And these are going to be factors which is going to help the apex court understand what dictates an irretrievably broken marriage or not.
Yes.
Because it's going to be a tricky slope for the apex court as well.
Yeah. Now, we are yet to get the fine print. Today, 10:35, the 5-judge bench pronounced the verdict, and they read out portions of the verdict, the operative portions. But there is much more to this verdict. There is much more in the fine print. And the court says that it will have to look at the rights of the spouse, the woman's spouse, that is, whether she has any rights to maintenance, whether an alimony has been properly worked out, if they have a children, what are the rights of the children there, who will have the custody of the children. Once these issues are sorted out, then that cooling off period can be dispensed with.
All right, Prithviraj Sikka, Supreme Court advocate, also with us on the broadcast here. Advocate Sikka, some of the questions and pertinent points that Ashok here in the studio is certainly raising, and also, your initial thoughts on the verdict that has come out.
Just I am telling you that around 20 years back, there was a Allahabad High Court judgment in which I had got the 6-month waive off due to certain reasons that after 1 year, they remained separately more than 1 year. I said that there is no purpose. Thereafter, they have not started conceiving, they cannot reside together. So in that case, 6-month waiver is something different. But in every case, court cannot directly grant divorce under 142. 142 is constitutional court, and High Court, Supreme Court has power to exercise this, but lower court cannot exercise. Under Section 13B, if there is mutual divorce without seeking the gestation period of 6 months, then court can waive off on the basis of the ground.
All right, and about Article 142 of the Constitution, there are many questions that have now come out in terms of how and when the apex court is going to be using these sweeping powers.
142 is an extraordinary power in those circumstances that if you have contested lower court and you are coming to Supreme Court, Supreme Court will not decide every divorce petition. There will be certain points in respect of the welfare of the children and their maintenance, their compensation. In respect of that, the wife is earning or not, husband is earning or not. It depends all these factors. So when a person who are well off and they are interested under 13B, then cooling period can be waived off.
All right. Ashok, economic rights of the children is something that I heard one of the judges speak about as well. Do you think this particular case, you spoke about alimony rights, you spoke about various adoption, allocation, succession, all of those things will now come into the fray as well. 13B, it seems, is untouched. Do you think it's going to be, there is a possibility that it might fiddle with public policy here, this verdict?
Well, as far as the stated public policy is there, which has been spelled out by the Parliament, it is that the cooling off period has to be there. Now, what the court is saying is that what we are witnessing is a new trend, where couples are coming to the Supreme Court straight away, saying that, look, we don't want to wait for another 6 months before a divorce can be pronounced. You have to understand that these are the couples who are in a rush, who are in a hurry to hatch on or to latch on to another marriage. Usually what happens is that the process in the lower courts is so lengthy and drawn out that the process itself takes 3-4 years for a divorce to come through, if it is not contested and if it's mutually acceptable to both the parties. What the court is saying is that, look, first we'll see whether the first fact is whether the marriage has broken down in such a manner that no repairs can be done. Number one. Number two, we'll see whether both the parties to the marriage are agreeable to divorce or not. The third part we'll see is that it's not just the husband and a wife who are parties to a marriage. There could be children. There are other children have rights. The woman has rights. The man has rights. Those rights have to be adjudicated first, and only then. Now, what has really happened in the past is there have been a large number of cases also that I have seen where couples do apply for mutual divorce. And this is a provision of law which was misused. What happened was, there were instances where educated officers who were married off early in their life because of their commitment of their parents, got married to somebody who is illiterate. But to honor the commitment their parents or grandparents did, they got into that marriage. And once they became sufficiently economically well off, they wanted to divorce their first wife and hatch on or latch on to another person. So what they did was that a woman who was illiterate, who came from a rural background, who did not knew her rights, she was given one lump sum of money. Say it was agreed that 20 lakhs would be paid to the woman by the husband to get out of the marriage, and he would ask her to sign a petition for divorce by mutual consent. We have seen a lot of such cases come up, and it was precisely to tide over any misuse of the provisions of law that the court had said, that the Parliament had said that you need a 6-month waiting period. We'll ascertain whether what you are telling us is true or not. There could be false facts which could be peddled in front of the court. There could be circumstances where a woman could be pressurized. There could be circumstances where the man in the marriage could be under some sort of a duress. So these are basically speed breakers which had been introduced by the Parliament. Now the Supreme Court is saying that, look, the provision of law stays. The 6 months cooling off period will be there. But if you come to us and if you are able to show to us
that you don't need the 6-month period,
and you have entered into an agreement and put to rest all our concerns with respect to child rights, maintenance, alimony, welfare, once that is done, then we'll possibly waive off that 6-month cooling off period. So what will happen now is that there will be a flood of litigation in the Supreme Court. Now, who are the kind of people who can come to the Supreme Court are generally the wealthy of people, people who can afford expensive lawyers. Coming to the Supreme Court or fighting a case in the Supreme Court even for a year or two, is not a cheap proposition. It takes money. Lawyers charge you money. And But one thing why people rush to the Supreme Court is that they believe that they will be able to get justice quickly.
And that's the idea of the entire verdict as well. In terms of how reformative this is, I'm going to ask this to Advocate Sikka with us on the broadcast here. Advocate Sikka, how reformative is this particular verdict in your opinion?
Actually, I have not seen the verdict so far. I am rushing to the court.
All right.
But according to me, that if they have settled, mutually agreed, both couple, in respect of the welfare of the children and everything, if they are coming under 13B, so in those circumstances, cooling period of 6 months should be waived off. This is my view.
All right. Well, Advocate Sikka here of the view that the 6-month cooling period should, inevitably be done away with. But it's actually nice. I mean, something is better than nothing. You can have that 6-month cooling period also if in case the court feels like you need it. In terms of reformation, your point of view, Ashok?
Well, this has been a long-standing demand, or actually people have been talking, members of the civil society have been talking about this issue. That what we are witnessing is that in the last few decades there has been a rise in the number of divorce cases where couples do not want to stay with each other, but they have been stuck with each other. The marriages have gone down the drain, the relations have soured over a period of time, but still they are forced to stay together because the law says that. However, the case that was made out here was pretty simple. Says a couple is here before the court, they say they want divorce, they are consenting. Both of them have agreed that they cannot continue in this relationship or in the marriage and they want a divorce. Then why is the technicality of law standing in their way? This is a technicality of law. The 6 months cooling off period is a technicality of law. They argued, why is the technicality of law standing in our way? When we want to part ways, why should it stand in our way? So the court says, okay, let's look into it. There have been a number of cases in the last decade where the Supreme Court has waived off that cooling off period. But, the problem arose that who can do it? Can the Supreme Court also do it? If the answer is yes, then under what provision of law or under what powers? So the Supreme Court said that, look, we have been given powers under Article 142 of the Constitution. These are extraordinary powers. These powers have been given to us to ensure that we do complete justice
To both parties.
To both parties, and while doing complete justice, we can tide over technicalities of law. We can set them aside, we can put them aside, we can ignore them. If justice is to be served, we can do all of this, and it can be done under Article 142. So today, these 5 judges in the wisdom said that, look, we believe that if a couple is going to come before us, make out a case that they don't want to stay together, then why should we stand in the way? If we are convinced, as judges, we are convinced, because at the end of the day, even a judge at the first level is the one who decides it. If we are convinced that the marriage is broken down in such a manner that it can't be repaired, let the husband and wife go their own way.
Yeah, why waste another 4 or 5 years? And like you said, it's not a cheap proposition visiting the Supreme Court either. But doing away with family courts, the word family, I mean, so heavily enshrined, entrenched in our value system, our moral system. What kind of ripple effect do you see happening when you've suddenly omitted something like a family court from something? A divorce, the holy matrimony between two people, something that is so intertwined with family values and system in our country?
Well, actually, the family court's jurisdiction has not been ousted. The family courts will still be the first court to file for a divorce. Family courts are the first courts in our country to decide on issues of marriage and divorce. If there is any dispute between a husband and a wife, and they want divorce, the family court will be the first court where they'll file an application for divorce.
So the procedure remains the same. It's just that in case you end up at the Supreme Court then has powers to annul the marriage if it feels like you don't need that cool-off period and it's basically satisfied.
So what's really happening here is that you are jumping two courts. One is the family court, the high courts. Two flights you are jumping and coming straight to the Supreme Court, saying that, look, we are not interested in waiting for another 6 months. Some people might have various issues. People in marriage, what is really happening in urban areas is that when marriages break down, the couples go their way. They don't stay even in the same house, even while the divorce proceeding is pending. They get into a dating game where they are looking again at their prospective partners. And what happens is that despite finding a partner with whom they would want to spend the remainder of their life, they cannot do so because an first marriage is subsisting, and until and unless that first marriage goes, he or she cannot enter into a second marriage. So these couples are in a hurry, they want to get on with their life, there is not much time, a lot is at stake. So they come to the Supreme Court and say, my lords, this is the case, we do not wish to continue with each other. Please waive off this 6-month cooling off period and grant us divorce immediately.
You know, I was going through some of the quotations from the hearing that happened in this particular case last time around. It's interesting, and we also have one of those graphics. We'll put that up. It says, we do believe that another question, this is coming from the Supreme Court, Ashok, we do believe that another question which would require consideration would be whether the power under Article 142, the sweeping powers of the apex court of the Constitution of India, is inhibited in any manner in a scenario where there is an irretrievable breakdown of marriage in the opinion of the court, but one of the parties is dissenting divorce. So again, a tricky situation.
Now, it's a very tricky situation. Number one, you have to understand that there are situations where parties at some point in time, while filing for the divorce, they agree, saying, okay, look, what I feel is that we can't stay together. It's a spur of the moment kind of a thing, and I have seen these ones. Or they are pressurized by their parents to file for divorce. On the spur of a moment, they sign a decree, they sign a petition for mutual consent. But subsequently what happens is that a couple of months or years go down, and then better sense hits one of the spouses, and the spouse says that, look, I think we still have a chance to save our marriage. So the court is saying that, look, we are even under 142, we will not stand in your way. If there is a glimmer of hope anywhere, we will want to see whether that option is exhausted. Only after exhausting that option, and still you believe that you can't stay together, then we look into it. But as long as one spouse is disagreeing, we are not going to exercise 142. 142 is for complete justice. And complete justice will be done after we have settled all the rights, we have seen under the facts and circumstances, we are convinced that there is nothing left. Only then this 6-month cooling off period will be will be dispensed with. If it doesn't happen, if we are not convinced, sorry, we are not going to.
So many peculiar cases, you know, it's so subjective and unique to all couples. And like you mentioned before, the litigation is going to increase multifold in the Supreme Court. And it's not a cheap process, but there is quite a huge possibility that the Supreme Court then again asks these couples to go into that particular cooling off period as well.
Yeah.
If the court is not satisfied,
if the court is not satisfied, the court will say we are not exercising our powers under 142. You better see, you will have to wait for 6 months.
Take the long route, essentially.
Yeah, take the long route. You are going to wait for another 6 months. If we see that in any way the marriage can be repaired or restored, then no, we are not going to do it. We are not inclined. That's been the stand of the Supreme Court, and the Supreme Court says that we believe that a marriage is a very sacred institution. Even though in the last few decades the whole idea of marriage has changed. The quickness with which couples are getting into marriage, in and out of the marriage, shows that the whole idea of a marriage being a sacrament is going away. Possibly, the society is evolving. Possibly, couples want to have a choice to determine their lives. If they don't feel comfortable with one particular spouse or their spouse, they should have this choice. Why should law stand in their way and say, no, 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 we want you to subsist or continue in this marriage? When both the spouses to the marriage are saying that we don't want to be together, who are you? Although the society has a vested interest in protecting the institution of marriage, but at the same time, how far can you push that vested interest?
And by the end of the day, it's the choice of the individuals, isn't it, who are, party to that holy alliance, that matrimonial alliance per se. Of course, Ashok, it has been quite a riveting conversation with you on this one. Before we, close this chat up, do you think this particular verdict is going to then, become a precedent for some other, legalities, some other acts and sections? Because the one that you're talking about this cooling off period, I can draw certain similarities to the 30-day notice period of the Special Marriage Act. People saying, let's do away with it. But then again, it's a safeguard and you might need it at some point in time. The same goes with this 6 to 18-month cooling period as well. But in terms of this particular verdict, do you see it, lending help or taking away from some other acts somewhere else?
Well, at the moment, we don't see, as far as matrimonial cases are concerned, we don't see at the moment that instances have come where the couples have come to the court and said that this is a provision or this is a technicality of law which is standing in our way. Okay. Now, tomorrow, couples, today what we are witnessing is that couples are in such a hurry that they want to get divorced the very next day. It can't happen. It can't happen. They would want these things. These are all aspirational as far as couples are concerned. But at the end of the day, as I said, that even a society has a vested interest in protecting an institution like marriage. It cannot just let it crumble away at the whims and fancies of individual choices. Individual choices are also important. So there has to be a balancing between society's interests and individual choices. And that's a very tight rope to accomplish. And the Supreme Court is also saying that, look, what we are going to do is we are going to side with the societal interest, but at the same time, what is really happening is a huge wave of individual choices are also have to be, accommodated. So what we'll do is we'll try to do a balancing act and see if a technicality which is standing in the way of a mutual divorce, we will dispense away with it.
Well, absolutely. I remember in the same particular case, you had the judges talking about that it's easier to pass a law. It's much easier to, pass, a judgment or a ruling. But it's much more difficult for the society to inculcate that particular verdict and really, start implementing it. That takes a much more time. Ashok Bagria, legal editor, many thanks for joining with us. It seems the verdict is out. The Supreme Court can, in fact, according to it, exercise its extraordinary powers under 142 to annul an irretrievably broken marriage and dispense away with that 6 months of cooling off period if the court is satisfied that these two individuals with mutual consent have agreed to, call it off, call their holy matrimonial alliance off. Well, that's all the time we have for you in this edition. Ashok, many thanks for joining with us. Lots more coming right on the other side. Keep watching News9 Live.